All right, let's be on the record in two cases, those being 2019 CR 1246 and 2020 CR 580, both captioned State of Kansas versus Danny Sport. Would the parties announce their appearances, please?
May it please the court, the state appears through Maurice Brewer.
May it please the court, John Kitchen, appearing on behalf of Danny Sport, who is present and in custody and on video for both of his cases.
All right, we are here set down today to take up the defendant's motion for a bond reduction. Mr. Kitchen, I would note for the record, you filed a written motion and I have reviewed the same. In this case, I can, if the parties desire, I can share it so that we can all look at it.
Judge, I think the state should have a copy of it because it was filed electronically, and so it was served to the state. So they have it.
All right. In any event, here's the motion. Like I said, and Mr. Kitchen, it is your motion. I will hear your arguments.
Thank you, Judge. Judge, this is actually two bond motions because my client, Mr. Sport, has two cases. In the case ending in 580, that bond is set at $25,000 cash or surety, and we are asking for a reduction to either a signature or PR bond or an amount the court deems appropriate. Regarding my client's second case, ending in 1246, Judge, I don't believe there's no bond set for that case. And so, number one, we are asking the court to, grant him a bond in that case, and preferably a signature bond or an amount the court deems appropriate, dollar amount it deems appropriate. Judge, one thing that is not in my motion, but my client just brought to my attention when we went to the breakout room, is he just told me his mother's got like a serious medical conditions, cirrhosis of the liver. He did not inform me that when I saw him at the jail before I, saw him at the jail and drafted both bond motions. So I'm orally asking the court to consider that at this time. If my client I would note, Judge, Mr. Sport is, was basically born and raised in Wyandotte County, has lived there his entire life. It's my understanding after speaking with him that if he were to bond out, he would live with a friend of his, a Gary Hurst, at 3136 57th Street, Kansas City, Kansas. Regarding his employment situation, Judge, he was unemployed when he got arrested, so he does not have a job at this time. He would like to seek employment, but obviously he does not have a job at this time. Regarding his criminal history, Judge, it's after speak with Mr. Sport, it's my understanding that he is in the A box on the grid, presumptive prison. And what created that was two juvenile convictions, felony convictions in either 1992 or 1993 in Wyandotte County, and an aggravated burglary conviction out of Johnson County, Kansas. In addition, he does have other felony thefts convictions in Kansas, and he's got a theft / tampering conviction out of Clay County, Missouri.
All right.
It's for these reasons of the court asking for, in one case, a reduction, in the other case, at least a bond set, and and preferably a PR bond, if the court would have deemed that's appropriate.
All right. Mr. Brewer.
Your Honor, the state is opposed to the bond reduction that's asked for in the newest case, that and the state would request that the court set the bond in the 2019 case at $10,000, basing that upon that among factors that in KSA 2802, among some of the factors that the court can consider include whether the defendant's prior convictions, his risk of flight, and the likelihood that the defendant would commit new crimes In this case, the defendant's already pointed out that he is a criminal history A. I agree that 2 of those convictions are from a 1992 conviction for aggravated robbery, and that he has the 2008 conviction for aggravated burglary. In addition, he does have quite a few convictions that are kind of in the realm of burglary and theft. In this case, he's already proven that he's a flight risk. He was already given he was already released on his own recognizance and to be supervised by pretrial release. While doing that, he then failed to appear for his preliminary hearing back on February 20th of this year, and that he never did turn himself in after failing to appear, and that he was only picked up on August 21st, where he committed some new crimes, or alleged to committed new crimes, and was subsequently charged with the aggravated burglary, criminal threat, interference with law enforcement, criminal possession of a firearm, domestic battery, and assault. Given the fact that he is already a presumptive prison due to the person felonies convictions, that shows that that gives him a high incentive not to come back to court, given the fact that he already failed to appear for the preliminary hearing that was set in the 2019 case. The state remains opposed to the bond reduction in the newest case and would request that a $10,000 cash or surety bond be set in the 2019 case, Your Honor.
All right. Well, look, there's a couple of things. I think he's entitled to a bond on the old case. He got picked up as a bench warrant. I understand that, and that's a consideration in setting a bond, but I don't know that it rises to the level where this court feels it's justified to hold him without bond on an ongoing basis. So I'm going to grant him a bond in the 2019 case. That bond will be $10,000 cash or surety. As to the motion for reduction in the bond in the new case, these are just allegations there, and I recognize that. However, they are particularly concerning. There's a couple of things that I'm supposed to consider in setting bonds. One is whether the defendant poses a risk to society and or in particular to the victim in a case that would justify at least setting a bond that would make it reasonable for him to appear, but also address public safety. And frankly, we have a defendant who's a criminal history A. I understand that his last conviction here in Kansas was in 2008. That may be well thankful to the fact that he was in DOC until 2017 on those charges. So he has not been released on an extended period of time and has picked up 2 felony cases in the approximate 3 years since he's been released. These are allegations of a domestically violent crime and that a handgun was used in that. In fact, the allegations are that the officers found the defendant in possession of a firearm, which again, just allegations at this point.
Excuse me one second, I'm sorry.
Danger to the community.
Yeah, I'm sorry.
That
Can you give me-
certainly argues to the point that he does
Judge,
pose a
I'm sorry.
substantial risk to
Excuse
the
me.
community if he were released in these cases. Yes, Ms. Lowe.
I've been trying to get your attention for about 15 seconds, maybe.
Okay,
I had myself on mute and my dog was going crazy and I couldn't hear you even the last.
starting, where did we leave off?
The allegations another crime has happened, a gun was used in that. Allegations are that the officers found the defendant in possession of a firearm.
All right. And again, these are just allegations. However, I do think that they show that the defendant poses a substantial risk to the community if he's released, or if he's released on his own recognizance. The second factor is whether or not the defendant can be said to pose a flight risk. He had a bond, in fact, a signature bond that he's asking for again today in the old case. He did not appear for that case, and he'd never turned himself in until he was arrested on this new case. So he does also pose a substantial flight risk if released. So I think denial of bond altogether is not called for in this case. However, modifying that bond to a signature bond or lowering the cash amount at this time is not appropriate for both of those reasons. So in the new case, the bond is going to remain at $25,000. In the old case, it will be a bond will be instituted of $10,000 cash or surety. And that is the court's ruling today. We are set for prelim in November. Are there other things we need for our record today?
None from the defense, Judge.
Mr. Brewer?
No, Your Honor.
All right, we are adjourned. We'll see y'all in November in person.
Thank you, Judge.
Thank you.
Every day.